Okay, Hannah, we all ready to go?
Yes, we are, Mr. Chairman.
Okay. It being 1830, not 1930. We didn't get our clock changed. As the vice chairman, I will call to order the regular meeting of the Garden City Planning and Zoning Commission for Wednesday, March 18th, 2026. Let the record show that vice chairman, myself, Mr. Commissioner Brown, Commissioner Shepard, Commissioner Smith, and our new member, Commissioner Bickerton, are present. The chairman, Commissioner Montoya, is absent. First thing I want to do is I want to welcome our newest member. This is our first meeting with us, and we'd like to welcome Rachael to be here with us. And I'm positive she's going to be a really great addition to our body. And with that, everybody please stand. We'll pledge allegiance.
Pledge allegiance to the flag, United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Chairman.
Okay. We've called to order. We had the Pledge of Allegiance. And the first thing we're going to do tonight, we're going to be a little bit out of order, out of the ordinary order. And the first thing is listed on here is item number Roman numeral 4, a discussion. It's something I personally asked, and I really think she does a great job. That since we had a new commissioner on board, and the rest of us need a booster shot every once in a while to remind us what our duties are all about and the way we're supposed to be acting. And so Jenna will give us a little briefing tonight on Planning and Zoning Commission on our duties, roles, and decision making.
Chairman and members of the commission, to start off, I wanted to just second that welcome to Commissioner Bickerton. And then tonight, as each one of the commissioners are onboarded, we have a reference online that has several different reference documents, including this PowerPoint presentation. So hopefully you, at least at some point in time, have seen this. And it's quite long, so I will run through it as quickly as I can. I'm happy to slow down if you just interrupt and say, let's talk about this component a bit longer. I'm also happy to come back and break this into chunks. But for tonight, I'm just going to kind of go very quickly through this presentation. So there are a number of reasons why we want to plan for the future of the city, and in doing so, why we want to zone. Planning allows for buy-in and vetting of issues, make sure that there's adequate facilities and services, and looks to the health and safety of the community, also can look for economic development as well as stability and equity for those who both live and work in the city, and certainly for those that may also want to visit. And then zoning is a tool to help protect property rights on both sides, both for those that got here first and then those that are hoping to come and join the community. It can provide for resource protection and health and safety, and as already mentioned, it's a tool to implement the plans. I did not come up with this analogy, but it's one I heard probably 20 years ago that really resonated with me. there are different systems within the city that all need to work together. And if any of those systems are out of whack, just like a human body with the human body systems, one of the systems could make the whole unhealthy. And so you can make whichever analogies that you would like, whether the transportation is the bones or the skeletal system, et cetera. And here are just some examples of, maybe there are even rules related to these, and if you don't get the rules right, it may not result in a desirable place to be. But if you do get the rules right, you really can affect the community. The foundation, the ability for Garden City to have planning and zoning ordinances, development ordinances, comes from the federal all the way down to LUPA. And Idaho is a state that's called a Dillon's Rule state, which means that you have to be explicitly granted powers by the state to be able to implement those duties. And again, as I just mentioned, the state statute that enables planning and zoning regulations for Garden City to adopt them is LUPA. Planning is kind of like that picture on the puzzle box, but often here the commission is putting those individual puzzle pieces together to make the whole vision work. And that starts with the comprehensive plan. In most instances, the Garden City Comprehensive Plan or any comprehensive plan in Idaho is not legally binding. Prior to being here in Garden City many years ago, I was in Florida, where it is a legally binding document. But in general, the exception, there are two exceptions, but any zoning map change needs to be in compliance with the comprehensive plan or directly not in conflict in some instances. And your ordinances, as you adopt ordinances, should be consistent with your comprehensive plan. And the comprehensive plan is just one of the layers of the city's vision, but it's that foundational document, particularly in land use. But it should look to all of the systems. Once again, it should look to safety as the police department looks at it across the board, as in the police department is just one example. But the city has a number of adopted plans and visioning processes that it's gone through over the years. And the development code is just one tool to implement the plans. There are many different tools. And so there are policies, public investments, agreements, etc. And then the Planning and Zoning Commission may see two different types of actions. The first is a legislative action. In that situation, the Planning and Zoning Commission would be a recommending body if it comes to this board at all. And the legislative actions, I think there's another slide further on, are a little bit more lenient in your ability to interact with people in the public. And you can have a bias in a legislative action, et cetera. And so some of those examples of those might be the master plans, the comp plan, ordinances, capital improvement plans, and then area of impact. And you probably won't see too many moratoriums, but if you did a moratorium. And then usually yours, although it's not quite true tonight, well, it is true, you're seeing administrative actions tonight as well as legislative actions. Administrative actions that require a public hearing, and so those coming before you are called quasi-judicial actions. And some of these types of actions that you might rule on are conditional use permits, rezones, subdivisions, annexations, and variances. And so there's a lot going on with the puzzle piece when you have quasi-judicial decisions. You're looking at the property itself, the effects on other properties, how it interacts with the Garden Cities Code, state and federal statutes, easements, agreements, other systems, et cetera. And then just some of the relationships that you have as a planning and zoning commission. The elected officials ultimately set the stage. They adopt the legislation and policies. And then the commission is acting on quasi-judicial matters and a recommending body for a lot of legislative matters. We have a process for design review where we have design review consultants that are making specific recommendations on design review. You're interacting with staff, the public, developers, businesses, experts ranging from engineers to architects, and I've even seen experts on indoor shooting ranges come before the commission as an example. You're dealing with media at times, and certainly there's effects on other jurisdictions. This is just a comic about how all those different relationships understand a project differently. So some of these say this is what the customer wanted and what they were given by the project leader, their architect, how the city regulated it and how they were billed, etc. As already noted, the mayor and council set the policy and direction. Since they're elected, they respond to the constituents' needs directly. And they have deferred certain decisions via code to either you or to staff. But in case of appeals, any appeal will appeal up to the city council. As a commission, you're providing a means for hearings to the public. Your advisory is noted 12 times. At times, you're the final decision maker, for example, in conditional use permits. Your actions must be consistent with code and adopted policies. And for a long time, any decision has been required to give reasoned decisions. But that has become a little bit more clear in about the last year or so, where the Supreme Court noted that the reasoned statements must address all disputed matters and must fully be well vetted, I guess, and discuss the record in its entirety. And in instances of denial, decision document must also include what an applicant can do for approval. And then some of you might not know that you're the appeals board for building code. So if the building official makes a determination that's appealed, that will come here. That hasn't happened for years. And then there may be appeals that the planning staff, you may hear appeals from planning staff decisions as well. The design consultants are applying code, but I think that this picture that I pulled off the web years and years ago really shows a good example of just how that is implemented can really make a difference. And sometimes there's overlap. Parking is a great example, or sidewalks are a great example of where there's overlap between the design and the use that you'll often see in conditional use permits. Again, there's lots of other jurisdictions that we're interacting with, ranging from utilities to schools to transportation, or other departments that you're not directly interacting with on a monthly basis, such as public works or the police department. LUPA does require that most applications that you'll deal with are sent out to those other jurisdictions and agencies. And then a big part of what you do is hear the public. Staff, we're here to process and do as much as we can to help your job be a little bit easier. And we can provide professional expertise. We certainly work for you, but ultimately we're accountable to the mayor. The commission, there are rules about our meetings. The meetings need to be noticed per state statute. All meetings need to be transcribable, or matters that we deal with need to be transcribable. The commission must have at least 9 monthly meetings a year. And for quasi-judicial matters, it's really important to note that your decisions must be based on what's in the record. To be a commissioner, you were appointed by the mayor and confirmed by the council. You must have lived in the county for 2 years and reside in the duration. And that's not quite true anymore. And so the city has, I missed taking that off the slide. The city has opened that up to if there's a business owner on the commission as well. A good commissioner has or will familiarize yourself with the comp plan and the vision of the city over time. And you can always reach out to staff. We're here as a resource. And over time, better and better understand the code. Again, staff is a resource. But I have no doubt for the audience that this commission does their homework ahead of time. We speak to them, we know that they do. But if there's a question on the application, certainly staff is a reference. So as long as it stays within the record, and then if there's something that needs to be added to the record, we would do that and notify the other commissioners and applicant, etc. A good commissioner is engaged and respectful, but can have a different opinion at the same time, and is able to communicate effectively and efficiently, is objective, and can make meetings. So here's the big stuff. If there's a conflict of interest, if you or a family member has financial has the ability to have financial gain or loss due to an application, we would request per statute that you recuse yourself. And in Garden City, we ask that you actually leave the room just as a best practice. And if you're not quite sure, you can talk it through with the Garden City attorney. You don't have to supply a statement describing the conflict. And then again, as already noted, in quasi-judicial matters, you can't be biased. You have to review the record and only the record and make your determination on that. However, on legislative matters, you can have preconceived notions that you bring with you or discussions outside of the record, which brings us to ex parte communication. You can have ex parte communication, but we strongly recommend that you avoid it because it just makes things harder for you because you need to disclose that. But sometimes we do know that a neighbor grabs you at the supermarket and asks about an application, and you just need to disclose that if that occurs on the record. And ex parte does not apply to staff again, so you can speak to us. It should go, I should have said when we were talking about open meetings, that you can't confer with your fellow commissioners. And that can even go to just a reply all on an email. And so if we send out the packet or a note and you have a question to us, even if it's pertinent for the other commissioners, we request that you just hit reply and we can respond to you, and then we can send the same information out to other commissioners. This is talking about findings. Your finding must be based in records. Your findings need to be supported by the record. And if a hearing is continued, we usually request that it's continued to a date certain because it's easier. We don't have to renotice it. Otherwise, we do need to renotice it. There are adopted procedures which can limit public testimony to 3 minutes and applicant presentations to 15 minutes. Sometimes there are applications where that's just not a possibility. There's so much information that the applicant is going to need to convey to you that there are allowances to allow that to go longer. And the findings must be made in writing. That's why we provide a recommended decision ahead of time to help, so you're not trying to do that all from the dais the night of. But those decision documents need to know which ordinances and standards were reviewed, provide the reason statements for approval or denial, the actions, if any, if an applicant is denied, what they could do for approval, and evidence. The staff report has that you receive on all application types kind of has a standard list of record documents, recommendation, discussion, project information, decision process, agency comments, public comments, and then the code and policy review. We've already gone over the decision document, and I've touched on open meeting laws. And procedural rules are found for development code. Procedural rules are found in Garden City Code 8, Title 8-6. And then we also have a new resolution for hearing procedures. It was actually in your matters tonight. And then some common mistakes. If the decision can be found to be subjective, isn't clearly backed by code, or not clearly backed by evidence, or in violations of regulations such as the Fair Housing Act, that might be reasoning for decisions that could get us in a little bit of hot water. And we've already talked about having no meeting outside of a scheduled meeting, so the reply all, or not creating a clear record. I think that's probably one of the most common things that could happen. And then this is available on the Garden City web within the section for Planning and Zoning Commission resources. With that, I stand for any questions.
Any commissioners have any questions? I do suggest that you either have a copy of this, which is on the site, and that you get yourself a copy that you have reference to. And it's really important, what Jenna said. If you got any questions, remember, just get a hold of the staff. I find them to really be good. They always answered any questions that I had, and so that's the people you want to go to find out if you have any questions.
Chairman, if I may, just to follow up on that, on the website under the Commissioner Resources, former Commissioner Wild had worked for the city of Boise and asked Boise if he was able to provide something that he had put together years and years ago, similar to this, but in a format like a white paper format, that goes into a little bit more depth instead of looking at pictures, if that's also a resource that you'd be interested in.
Okay, thanks, Jenna. All right, now we're going to proceed with the agenda, and we're still a little bit out of the regular sequence in that we're going to have item Roman number 4, a discussion. And what this is about, back in, I think it says in there, September of 2024, this body heard some amendments to our the code, the Garden City Code. And so, and we recommended approval of these amendments. It went to the city council, but they did not finish. Got the request of the attorney, the city attorney. It was held in abeyance because of that court case, the Veterans Park Neighborhood Association versus the city of Boise, having to do with the interfaith sanctuary case. And so he decided that it'd be a good idea to hold off on these to make sure that the changes that were being made were in conformance with what the Supreme Court of Idaho had said. And subsequent to that, it's actually resulted in a bunch of changes that they had to make in Boise City. And if I understand it correctly, they're going to proceed with this, but they requested that we be briefed up on this. And if I understand it correctly, there really weren't any substantive changes made from what we already saw. However, I've asked Jenna to go over and just remind us of a couple of the important changes that were involved in this. And then afterwards, Jen and I talked about it, and what I would like to do is I'm going to ask for a motion afterwards to the effect that we are reaffirming our support for the proposed amendments. And so when Jenna gets done, if you have any questions pursuant to that, then let's make sure we ask Jenna about it. Okay.
Chairman Brown, members of the commission, thank you. That was a very great introduction, where it's hard to compile not the changes to the ordinance, but the history, and that was well done. And so, yes, the PNZ, or the Planning and Zoning Commission, has already recommended approval on this ordinance. It's gone through 2 readings, and the city council remanded the ordinance back to the planning and zoning for any changes that may occur. This isn't scheduled as a public hearing. That public hearing will be scheduled in front of the city council. There aren't a lot of changes from that initial ordinance caused by the Supreme Court and the pause, and that the code was already really addressing some things that it needed to, and some of the things that the city's addressing as a result of that case, we're doing administratively. For example, you've probably noticed that the draft reason statements are much more robust than they used to be. But since that second reading, there have been some changes. The first one is, in 2019, there was an ordinance that was adopted and it just wasn't correctly codified. And so that there are some changes to the terms of the commission, just referring to state statute instead of trying to be a procedural handbook within the ordinance. And those changes are consistent to those that are already made. Staff just decided it'd be easier to include it in the ordinance instead of have the codifier go back to that original ordinance. There's clarification to what processes are administrative with public notice, and public hearings, and what that means. There's clarification between the differences of when a design review is administrative with notice processed in that regard, or when it goes to a public hearing. And it follows along with how it was intended. It's just staff's had more time to look at it and give it a few tweaks to try to make it a little bit more clear. And then the big sweeping change that you'll see is recently the city adopted a resolution dealing with public meeting and hearing policy. And so all of the information that can be incorporated in that resolution or is in that resolution is deleted out of the ordinance. There are a few minor changes to that resolution that staff has recommended. It's highlighted in that policy that was included with these materials. And then the same thresholds for design review when design review is triggered is in code, but just clarified on how that is interpreted by staff. So that can be more subjective when an applicant comes to us. So those are the changes that were made, and probably the things that you might care about from the original ordinance, just to backtrack a little bit to refresh your memory. What that original ordinance was trying to do was really grapple with how should those administrative with notice or design review processes be handled. And it is an appeal unless it triggers a public hearing. And basically what a public hearing, when a public hearing would be triggered is if there are 10 households or more that comment into the city. And then staff would notice that as a public hearing. With that, I stand for questions. I'm happy to give even further background since I jumped over that.
So any commissioners have a question about this?
Mr. Chair, I just have one question about the table and specifically the appeal section of the table. If I understand it correctly, what we're saying is that it's not a de novo standard, meaning that an appeal will only be granted if the higher body finds that decision was capricious, abuse of discretion, et cetera, a fairly deferential standard to the lower body. But then, and then assuming it's granted, it's a closed record, so not de novo. But in the grant, appeal, and modify decision section, it said modifications may be made when new evidence has been added to the record or an equally good or better decision can be met. And I thought that language was a little bit confusing, because if we're saying it's not de novo and it's a closed record, there shouldn't be any new evidence. And if the granting of the appeal was based on it being arbitrary, capricious, et cetera, then we're not really talking about an equally good decision. We're saying that there was something wrong below. So I think that box doesn't really fit with kind of the rest of the framework for appeals.
Chairman, Commissioner Smith, I absolutely agree. Thank you for catching that.
Great. That's all I have. Looks great.
Okay, any other commissioners have a question about any of these changes? I don't, so I think what we still can proceed with what I suggested. I would request, and the fact I will ask Commissioner Smith to make a motion in the vein of what I suggested, but noting that it including your recommended change.
Okay, certainly, Mr. Chair. So are we, is this or just recommending
it should be,
approval?
we're recommending approval of,
Okay.
of these changes.
Then in that case, I move that we recommend approval of CPA FY 2024-0005 with just a correction to the chart to change the modifications section to be consistent with the rest of the changes in the code, that it is a deferential standard with a closed record, aka not de novo standard.
Do I have a second?
A second.
All right, we have a motion and a second. Anybody want more discussion? If not, we will call for the vote. Everybody in favor of the motion indicate by saying aye.
Aye.
Anybody opposed, nay? And the chair votes aye. Right, now we're going to proceed now with Roman number 5 in what is pretty much the normal sequence that we normally do. And so first thing, staff, do you have any changes to the agenda?
Chairman, none at this point. Thank you.
Okay, we don't have any
Oh,
changes to the agenda. The next item is the
Chairman,
consent agenda. So,
I misspoke.
pardon?
Just one thing to note is I misspoke on the changes to the agenda. Item number 8B will need to be continued to a date certain of April 15th
Yes.
to remedy noticing errors.
That's fine. And I will note that again here in a couple minutes, please. Okay. So the next item is the consent agenda, and with the addition of this change was just mentioned, what's on the consent agenda are the approval of the minutes. However, the minutes for the February 18th meeting. However, consent agenda, the purpose of it includes items of business which may not require separate discussion and as independently. And consequently, in an effort of not prolonging our P&Z meetings the longer they need to do, we take an opportunity to try and consume other things that are on a hearing process and including them in the consent agenda. So we're going to consider doing that for every item that's on item Roman numeral 7 and number 8. And so I will just go down them in order and we'll find out if we're going to do that, all right? And the first item then is zoning FY 2026 number 2, Curtis and Crystal with BRS Architect requesting a rezone of 4.59 acres of property located at 4902 West Chinnen Boulevard. Is there anybody in the audience, including on Zoom, who would like to give public testimony on this item? I see that there are none. Is the applicant present? Yes. Sir, please state your name for the record. Have you had an opportunity to review the findings of fact, conclusions of law, and draft decision, including draft conditions of approval? I have. Do you agree and consent to these documents in the affirmative, including all conditions of approval? Does staff or any member of the commission have any reason that they feel that we should hear this separately?
None by staff.
Any commissioner?
No, Mr. Chair.
All right, then when we get around to making a motion, we will move that item to the consent agenda. That'll be the first item that we've moved. The next item and in Roman numeral 8 under new business public hearings. The first item, and by the way, that last one, we were a recommending body for that last one. The next ones, these CUPs, conditional use permits, we are the deciding body on those relative to that little talk that Jenna just gave us. So the first one is item number A, conditional use permit FY 2026 number 4. Hash Design Architecture is requesting a conditional use permit for a new 2,000 square foot 2-car garage and 6-foot privacy fence on a 0.54 acre lot located at 4708 North Fenton Street. Is there anyone in the audience who would like to give public testimony on this item? The file number was again CUP FY 2026 number 4. You want to do that separately, so you want to have that heard. All right, then we'll do that. Okay. Are you the applicant? All right, then let's have it indicated that the applicant. So we will not move that one. We will not move that to the consent agenda. Okay, we will actually have a public hearing on that, and I'll go over the process for that when we get to there. Okay. The next item is item number Roman numeral 8, number B, CUP FY 2026 number 6. Conditional use permit Brian Schneider with Intelligent Design Mechanical Solution LLC requesting a conditional use permit for service provider at 4290 West Chinden Boulevard. And that, as was already mentioned by the staff, we will move that to the consent agenda and for it to be a motion to continue it until April 15th. So that one, and that brings us to item number C, CUP FY 2026 number 8, conditional use permit. Matthew and Hope Smith are requesting a conditional use permit for vehicle service at 214 West 37th Street. That's 37th Street. Same situation. Is there anyone in the audience who would like to give public testimony on this item, number CUP FY 2026 number 8? How about in Zoom land? Apparently not. Is the applicant present? Would you please state your name for the record?
Hope Smith.
Have you had an opportunity to review the findings of fact, conclusions of law, and draft decision, including draft conditions of approval?
I have.
You agree and consent to these documents in the affirmative, including all conditions of approval?
I do.
Does the staff or any member of the commission have any reason why they feel this item should be heard as independent?
None by staff.
Commissioners? All right, then we'll move that one to the consent. So what we'll be doing, and I will be asking one of the commissioners to make a movement to approve the consent agenda, and it will now consist of approval of the minutes for February 18th, the rezone, the number 2026 number 2, CUP FY 2026 number 6, and CUP FY 2026 number 8.
Mr. Chair, I move for approval of the consent agenda consisting of the minutes and the matters that you just referenced, as well as moving CUP FY 2026-0006 to a date certain of April 15th.
Will I have a second?
I second.
Yeah, I can't because I don't know about the minutes. I can't approve the minutes. I wasn't there. So.
Right, that's probably right, since we're here. All right, we have it moved in a second for the consent agenda. Everybody in favor say aye.
Aye.
The chair votes aye. Anybody opposed? Apparently not. And so that takes care of the consent agenda. So now we're going to move on to the one item that we're going to hear. And that will be new business under public hearings. CUP FY 2026 number 4, conditional use permit from Hatch Design Architecture. And so let me talk a little bit about what the briefing, what the order, what will happen here. Okay. I will introduce it, which I've already done. I don't need to, maybe I'll read a little bit more. Conditional use permit, Matthew and Hope Smith. No, that's the length of the condition. The one that we're not is CUP FY 2026 number 4, conditional use permit, Hatch Design Architecture is requesting a conditional use permit for a new 2,000 square foot, 2-car garage and 6-foot private fence on a 0.54 acre lot located at 4708 North Fenton Street. And number two, the first thing that will happen will be a presentation by the applicant, and we'd ask you to keep that to 15 minutes. When we get going, that will be followed by the city staff report. Again, we will ask the staff to keep that to 15 minutes or less. That will follow a public hearing, and we're given an opportunity for individual testimony. Anybody that's going to do that, we will ask them to not take more than 3 minutes. And that will be followed by rebuttal testimony from the applicant, at which point we will close the public hearing and we'll have a discussion among the commission members on what we want to do about it, followed by a motion, and any further discussion following having to do with the decision will take place at that time. So with that the way, please, we would have the person representing the applicant, please give us your name and address, and you got 15 minutes.
Thank you. My name is Seringa Riley. I'm with Hatch Design Architecture, located at 200 West 36th Street in Garden City. Good evening, Vice Chairman Brown and the commissioners. Thank you for having us and hearing our conditional use hearing tonight. Our project is located on East 47th Street and North Fenton Street. It's right on the corner. It is a residence with a large yard. It has commercial to the south of it and a little bit to the west, and then residential on the north side. We are proposing a 2,000 square foot 2-car garage. It is 50 feet by 40 feet. They will be using it for their boat storage and RV storage. We are including frontage improvements, including landscaping, a new sidewalk, and a privacy fence. We are connecting the proposed garage to the existing residence with a path, and we are going to match the front of the existing residence with the material that we're proposing for the garage. So they will be matching there. And then there are 2 existing structures on the site. One is a small outbuilding here, and another is a larger outbuilding here, and those will both be removed. We met with the design review consultants about this project, and we brought the landscaping up to or in compliance. So we have a 10-foot landscaping buffer there. We are proposing using metal siding for the garage. This will also be on the front portion of the house to match. We are adding windows to the garage doors to help bring light into that space. We met with neighbors. They had some concerns stemming from a previous commercial project that was proposed on this location. They were concerned about noise, but this is a residential project, so there should be minimal noise, and there is no external mechanical equipment. This project is also much smaller than the previous one, so there will be less lighting used, and it will be kept within the restraints of the property. And lastly, they were concerned about the structure that is over the property line, which we expressed will be removed. And then lastly, working with the design review board and the staff report, we are in compliance with all of the applicable areas. And that is all. I will take any questions if you have any at this time.
Well, let's start at the right end. Commissioner Shepard, do you have any questions?
No, Mr. Chair.
No, Mr. Chair.
Commissioner Smith? Okay, I think that'll be, I may have some questions later on when we get to the rebuttal,
Okay,
but I want to hear what's being said.
okay, thank you.
All right, thank you. All right, we do have some people who signed up. So let me remind everybody how the hearing will proceed. All right, everybody that has signed up will get an opportunity to make a presentation. We'd ask you to limit that to 3 minutes if you could. And then that will be followed by an opportunity for the applicant to make some rebuttal after we get done with these. So the first person that is signed up on this is Sandy O'Shea. And do you want to make a statement up here?
It was just presented. I don't have any more.
You're just saying that you were in support of it. Is that what?
Yeah, the way she just presented.
Okay. That'll be fine. And we'll make a note of that. And I have her there. The second person that is asked to speak is Mr. Jeff Hatch. You're going to wait for the rebuttal, right? We'll do that. He's one of the applicants. And the next person that we have on here that wishes to testify is Syringa Riley. So both of you are actually the applicants. So I think anybody out there in Zoom land that wants to talk about this particular application?
Yes, Vice Chair, can you hear me?
Yes, we can.
Okay, great. This is Kayleen Richter. I'm a property owner to the northeast of the property. We don't have any objections to this project as amended. The concerns that I saw were, what staff has noted, the fence line, the encroachment on the drain property line, the lighting, the lumens, the direction of the lighting, and as the property currently exists, the pictures in the record that show storage use are accurate. And so just to be clear, as amended and as proposed today, I think the project looks great and we wouldn't have concerns with it how it is proposed. Thank you.
All right, thank you. Does anybody have any questions for Kayleen? I don't think so. All right. Okay, at this point in time, I would like for the applicant to come back up for that rebuttal. And why don't both of you come up?
Chairman, would you like a staff report?
Oh, I skipped right over it, didn't I? Well, that's a good thing.
No worries.
Good thing that you're keeping me straight. Yes. That's why she was looking at me like, what are you doing? I forgot what I was doing. I wouldn't skip right over you. Let's have a staff report because I do have a couple questions.
Chairman and members of the commission, I will keep my staff report very brief. I think that Ms. Riley's presentation addresses most of the issues within the staff report that staff member Ms. Anna Anna, I cannot see her name tonight, Antonova provided. But I do want to touch on the sidewalk issue. Garden City has a sidewalk policy that this commission worked very hard on in 2016. And it takes the code and addresses how to implement it. And there are location standards that are set forth in this policy that requires the detached sidewalk is required per code, except for in certain situations. And the policy itself is up. I don't know if you can read it that far away. It's pretty small. I can try to, it's not letting me zoom in. But those are if the sidewalk would be impeded by a structure, if it's contrary to an adopted plan, or if there's an existing attached sidewalk on both sides. And you can see here that both is actually italicized and bold. And so where this application has that condition on one side, it does not have it on the other side. And with that, I do think that Ms. Riley addressed all other matters that were identified in the staff report. I do also want to mention that the draft decision very clearly identifies that this is also going through a design review process, and the design review has not been approved yet. With that, I stand for any questions.
How about the commissioners, the other commissioners? Do you have any questions?
No, Mr. Chair.
I have a question I want to address having to do with the issue of the detached sidewalk. Is this applicant requesting that they not make the detached sidewalk?
Chairman, that has been staff's understanding that there is that request out there. The presentation, I wasn't quite clear if that's still a request tonight, especially with that green box over the compliance of the sidewalk. And I suspect that Mr. Hatch, when he provides the rebuttal, will clarify that for us.
So that's something when they come up for rebuttal, we still, it's not clarified specifically whether they are or not. In preparation for that, because I have had a discussion, would you explain, have you done any research and what have we done in that area immediately around this application with regard to this very issue?
Chairman, thank you. There's a bit of a split on Fenton with the available right-of-way. And that splits right around 49th Street. And so there have been other applications that have come before this board that have been required to put in the detached sidewalk consistent with what is being asked of this application. And those addresses are 4854 and 4855, or that application on Fenton Street. And then Fenton Street does narrow down, and it's harder to work within the available right-of-way further on down the road.
So it did, but there they did put in a detached sidewalk.
Chairman, that is correct. That application was required to have detached.
Are there any other questions that anybody out of the commissioners have a question for Janet? All right, now we did. Now it's time for a rebuttal testimony from the applicant. And I would ask the applicant to address, I think that just specifically if whether your questions are about this specific requirement and any of the other requirements that are recommended for accomplishment.
Good evening, Commissioners. Jeff Hatch with Hatch Design Architecture. Our address is 200 West 36th Street, Garden City, Idaho, 83714. Appreciate Director Thornborough's recap and staff report. I think that our design review is more or less done. We did get notification that since it's on a corner, we got to have signs posted on both streets. So we're redoing our neighborhood meeting to be in compliance, but otherwise I believe all of the requested documentation has been presented back to staff. In regards to the question on the sidewalk as proposed in our presentation and discussed with the client, if the commission so chooses to have us improve the sidewalk, and talking with the owner, he seems agreeable to doing that. And I did want to bring back up my presentation if possible. In working with staff, we are proposing to improve, as shown here, our sidewalk from our existing sidewalk on the east along Fenton Street, and currently we're extending that another 100 feet onto the property to the west of us to tie into an additional existing attached sidewalk. If the commission so chooses, we're certainly welcome to do that. And talking with staff, the ultimate goal of the Davis Drain area, which is behind our property, is to create a natural pathway in that area. And when I hear the ultimate goals of what Garden City staff wants, it reminds me of other great stories about Garden City. This particular applicant's from Garden City, and he remembers walking and hunting along the Boise River right next to the chart house back in the 70s, and actually having a couple Secret Service agent men actually come out and escort them away because Jimmy Carter was at the chart house. This is a fascinating story in that people naturally use that green belt. And now if you look at it today with Lincoln Louis, it's a major pedestrian thoroughfare. And so I look at these, kind of quasi-judicial questions of pedestrian access and how we're going to use them and how we're going to improve property off of the proposed property. So in talking with the owner, if you want the sidewalk along Fenton, there's a kind of a sidewalk there now, but it's not as nice as this one. This will be one that's in compliant and meets code. The other consideration that we were proposing is if there is anything to further the pathway along the Davis Drain, in my opinion, we would be interested in trying to help that mission out a lot more than Fenton Street, because nobody's going to really walk on Fenton Street. So with that consideration, the owner and applicant did make a suggestion of, if it would be more amenable to this commission to do a mural on the Davis Drain side to help promote the arts along that as an alternative to this sidewalk. That is something we did very similar and very recently in lieu of frontage improvements at the LED dance studio last fall, and which we presented in front of this commission. So in consistency with what has been proposed as an alternate solution in the past, we wanted to present this presentation as well as the feedback from the neighbors and a consideration of potentially improving something along Davis, such as a mural on the 50-foot side of this building versus the sidewalk. And I'll stand for any questions.
About the commissioners, have you, any of the other commissioners have any question about this?
If I may, Mr. Vice Chairman, so could you? I'm a bit confused as to what you're proposing instead of putting in a sidewalk. Do you mind just restating that?
Commissioner Bickerton, in lieu of the sidewalk that would be off of our property to the west of our property, we are still proposing to improve all sidewalk on our property and adjacent along East 47th, to the westerly edge of our property on Fenton, as shown in our site plan. The consideration would be in lieu of the 100-foot stretch west of ours, which is not on our land, if it is the purview of this commission that we make improvements along the Davis Drain. And in talking with our property owner and client, they were proposing doing a 50-foot by approximately 20-foot high mural on the north facing side, facing the Davis Drain on the physically proposed building.
Can I have a follow-up? Chair, follow-up? Sorry, so is there also consideration for a sidewalk on East 47th Street? You've talked about the sidewalk, if I'm understanding.
Commissioner
On
Bickerton,
50.
there's an existing attached sidewalk
Got it.
along 47th, and we will be connecting in that and improving the intersection as well.
Thank you. Sorry, first time, a little bit slow.
Great questions.
Mr. Chair, I have a few questions. I'm trying to understand the extra 100 feet. Is that something that the city or the design people asked of you since it's not your property?
So Commissioner Shepard, working with Director Thornborough, the consideration that if we can connect a detached sidewalk to our adjacent neighbor 100 feet away, then we would be in compliance. The other option would be to do a detached sidewalk, which would eliminate about 8 foot of the frontage of the entire length of the subject property. And in doing so, we would have to pull the drive lane, the private drive, and a majority of their frontage gravel back an additional 8 feet, which the applicant was concerned would be a substantial amount of land that they're currently using for yard space. So this was a solution provided by staff, which we appreciate Director Thornborough coming up with this resolution.
Okay.
As previously stated, the owner of the property is fine with this. This is what we submitted back for design review. In presenting to this staff, this is just an alternate to that.
I think what I'm going to want to do with this is, it's not ordinary, but I don't see how we can resolve this. I want to ask the staff. In fact, I'm going to ask some more questions, but I'm going to ask the staff to comment and help us out on what their response is on this concept. And then I got a couple other questions.
Chairman, thank you for clarification. I think what Mr. Hatch is referencing on this discussion occurred at design review, where staff had indicated that the sidewalk policy, if connected on both ends, does allow for that connection. I respectfully don't want it to be understood for the record that staff was trying to direct the applicant to provide additional facilities offsite from the property, but the sidewalk policy does allow for an attached sidewalk when it's connected at both sides.
I may want you to come back up and help me on Starr, do you have some more on that one?
No, not on that. Thank you.
Is that, or do you have another issue?
No, I was going to ask a follow-up question, but I think I understand better now. Thank you.
I want to pursue this same issue. So if you did this, you're advocating putting a sidewalk or a portion on the Davis Drain property. Is that correct? In lieu of this, or?
If you guys are wanting a green belt there, it would probably be asphalt. But
That is in the future in the plan, but there's no project right now that would enable us to do that. That's available, like. It's not even, I'm not even sure who has jurisdiction over the Davis drain, that we could go and do that. I would ask that at this point, I would like advice from the staff, what their thoughts are about that.
Chairman, members of the commission, my opinion as a staff member is that this is a little bit apples and oranges, where I appreciate the thought of the applicant trying to beautify a space that in the future may be utilized as kind of a green belt pathway. And they can control a mural on their property. Improvements in the Davis drain may be difficult due to ownership without knowing if any improvements would be allowed, such as an asphalt pathway. Chairman, does that answer your questions?
I think so. I think it answers my question. I do have another question. There were numerous other requirements in there that had to do with, currently there's a bunch of materials and stuff that's stored there that would be insinuated possibly commercial, and you're agreeable to all those other requirements that are in there for that being eliminated, etc.
Chairman Brown, we are, as well as removal of the building that is straddling over the property line.
Okay, I think then that answers my questions. Are there any other questions on part of the commission or the staff? Let's see, Jenna wants to make a comment.
Chairman, just one point of clarification on my thoughts too. The sidewalk adjacent to the adjacent property either would fully need to be within the right of way or have the adjacent property owner's permission to do that as well. And so that is a consideration for the commission tonight as well.
Right, thank you. Any other questions? Okay, thank you.
Am I allowed to ask a question here?
No. But you already signed up. Sure, we're still in a public hearing phase. So with that, I'm gonna let you come up. You did sign up. You can come up after he is done. Okay? Yeah, that would be fine. Unless if she brings something up that you want to respond to, I'll give you a chance. So would you give us your name and address, please?
Sandy O'Shea, 4725 Windward Court. I'm right there.
Okay.
So my question is, we're talking about sidewalk. This is the part of the sidewalk that's unfinished. That's going to be finished, correct? Okay. Then this gray area, Mom said in this drain, but there's a fence right there now. And I'm confused on what they're planning to do with that. Is that fence going to be removed? The old fence that is not on the property line? It's going to sit there.
Yeah, I don't think that's
okay. So I don't understand what the purpose of putting blacktop there. Is there the reason for that?
Ma'am, would you come over here and direct your questions to the commission?
The part I pointed out is part of Davis Drain when they put the fence on the correct property line. There's currently a fence that is not on the correct parking because the owner just put it there and we couldn't get him to take it down. I was curious what's going to happen to that fence, if it's going to stay or leave.
If the fence is not on their property.
It's on Davis Drain's property, but the person who previously owned that property put it up illegally and it's been there for several years, many years. I've been there 40 years.
I'm going to ask the staff what they know. If this fence is on their property, then if if it's a chain link fence, then it's going to come down. And if it's not on their property, it's somebody else's property. then
It's
it won't be.
nobody's property. It's Davis Drain. And I spent 3 years trying to find out who's in charge of Davis Drain and could never get any information on it. I'm sorry.
Yeah, no, that's why I understand, and I would ask the
And if you have any
staff if they
information on
get
it, I'd
that.
like to know.
I'm very well aware of issues that I've had in my past life with Davis Drain. And you're right there. I would ask Jenna, Hannah. if
So
they-
please look into that if you
if-
could.
If they, do you understand where the fence is that we're talking about?
Yes, I know, I live,
I'm
oh,
asking
she
Jenna.
does, yes. You know
Okay.
where it is?
Mhm.
Okay.
Okay, Jenna.
Chairman, thank you for the opportunity to respond. There is a condition of approval that all fencing be brought into compliance. If the applicant indicates that it's not their fence, I suspect that the city could go towards abandoned property measures and work through a code enforcement mechanism to address that matter.
But then what Jenna is saying is this applicant, it's not his fence. He's not responsible. We can't put a requirement on him to do
Exactly,
that.
that was my
But
question.
Jenna will ask the people in code enforcement to look into that particular fence.
Thank you.
Okay,
Could I have you
Yeah.
inform me also, because I'm there. If they do something to the drain, it affects
Yeah.
me.
so they will
And my
pursue that,
neighbors.
all right? They will pursue that, but
Yeah.
if it's not his fence, he
Oh, no,
won't be
that
able
was
to.
my question.
Yeah. All right, thank you.
Sorry.
We got any other questions? All right. I don't think you need to have another rebuttal, as I would be correct for the applicant.
Chairman Brown, just to kind of clarify the intent, if the commission chooses and feels that they would be more interested in having the start of this green belt, that is essentially what this client is proposing as an alternative to that sidewalk connection.
I think we have enough information about the sidewalk.
Thank you.
Okay. All right, thank you. All right. With that, I'm going to close the public hearing. Okay? And we will now discuss this among the commissioners about what we want to do about this particular application. And so we'll start with our new commissioner to see if she has on this discussion. We're going to discuss what we think we ought to do about this particular application.
It's not fair to start with me.
If you want, I can start at the other end.
Yeah, that would be great, because I think
Okay, I
I'm
think
trying
we'll
to
do that.
understand why.
All right, Commissioner Shepard.
Thank you, Mr. Chair. I'm trying to understand the sidewalk. I'm looking at the discussion in the staff report. So thank you for giving me a second. I did review this prior, but it wasn't flagged to me because I thought everything, that they were gonna do everything in compliance like it says on this application. So my understanding is they're going to complete the, says there's an existing attached 5-foot sidewalk along 47th Street, but that one's not complete and they're going to continue. It's not on the full length of 47th Street. So they're going to complete the sidewalk on 47th Street, but then on Fenton Street, they have the option of making an 8-foot one just in front of their property or extending it another 100 feet for a 6-foot one, thus maintaining more of their property.
I'm gonna wait for Jenna to pull up this map.
It's not a part of our discussion, but this as part of it, I would like for Jenna, if she can on this, if she would point out what the requirement as it is now worded in the draft decision document with regard to the sidewalk. Just with your arrow. Please.
And Chairman, the arrow is a little small, but it's running there. Google Maps is incorrect. It's saying that this is 50th Street. This is Fitton Street right here. And so the requirement is just to the edge of property. And unless the commission concurs with the applicant's proposal to bring it to tie into this sidewalk down here.
So I think I heard from the applicant that they're proposing to bring it down to tie into the sidewalk further down, or they want to do a mural. Is that correct? Since I'm not familiar with the, like, adding onto the green belt, is that how you were phrasing it? Or like the Davis Drain area, I have a hard time imagining that. I would like to see the sidewalk just brought into compliance with the code. That's my discussion on that.
On this, and then, in other words, you're in favor of the way it's written in the decision document, correct? The requirement is written in the decision document, correct?
Yeah, I didn't see that highlighted, but I want to just review it really quick.
That requirement
maybe
is for
reduce to 4
attached
feet.
sidewalk to the edge of their property.
And include,
Okay.
yeah. Yes, I would be in favor of that, but that's saying it may be reduced to 4 feet, and I thought I saw something I wrote down that it could be 5 feet. I don't have the sidewalk code right in front of me.
Jenna, could you just read that requirement to us, please?
On page 8, number 11 of the draft recommended decision document, it states that a detached sidewalk shall be installed along Fitton Street. The minimum detached sidewalk width may be reduced to 4 feet. Required street trees shall be incorporated into a green buffer along Fitton Street. A minimum of 5 class 2 or 3 shall be installed along Fitton Street. A private driveway with 2 curb cuts along Fitton Street shall be approved by ACHD.
Okay, they can be reduced to 4 if they want. Okay,
Yeah, I'm in favor.
were there any other comments?
Mr. Chair, I agree with Commissioner Shepard. I think the sidewalk should connect, and I agree with it as it's stated in the staff report.
Okay, and how about our new commissioner?
I believe that my understanding is correct, that as reflects, I was struggling the same as Commissioner Shepard with actually understanding what we're reviewing. So if I'm clear that that what we just read and in the decision draft decision 11, that is what current code requires. Correct. This would bring it within code. Then I agree.
Do you have any other comments on this? How are you going? So if I understand it, all right. I happen to be in agreement with the other commissioners, and I'm gonna do a little explanation of this. I understand what you're saying, that there's a whole lot of problems with trying to put requirements onto an applicant that would go off of their property. And what, unfortunately, Davis Drain, there are all kinds of legal questions having to do with who is really responsible for Davis Drain. And it gets all involved in when he gets into it. And so I don't believe that this body has, we don't have the power really to have somebody put something else on that drain or to extend something beyond their property. We're going to do something else. And I am in favor of doing what is in the code. I'm very strongly in favor of that. One of the reasons that we don't have sidewalks and stuff in Fenton Street and all those other parts of the old part of Garden City is because 20 years ago, and even before that, this body did not exercise responsibility and require sidewalks to be put in accordance with the code. And so unless there are really good reasons, this commissioner has always stood pretty fast on our requirements, and especially since in the area on Fenton Street, we apparently have required other applicants to put in a detached sidewalk to the code. So what I'm in favor of is recommending not recommending, approving this. Approving this with the requirements as written. And given that, is there any other further discussion on the part of the commission?
No, Mr. Chair.
Okay, I would request one of the commissioners to make a motion, please, incorporating what we have decided in this discussion.
Do you want to?
I can take a stab.
Sure, go for it.
Mr. Chair, I move to approve file number CUP FY 2026-004, conditional use permit for Hatch Design Architecture, with the draft decision document as written.
Including all the findings of fact, conclusions of law, and requirements, right?
Including the staff recommended findings of fact, conclusion of law, and decision as drafted by staff.
That's good.
Second.
All right, it's been moved and seconded. Any further discussion on this application? I'll call for the vote. Everybody in favor of approving this of the motion, indicate by saying aye.
Aye.
The chairman votes aye, and there being nobody opposed, passes. Okay. Wow, I think did we finish everything? Anything else I forgot besides having the staff give us a briefing? If not, then I'm declaring us adjourned at 2050, or no, it's not, it's 1958.
Well done.
Thank you.